what's going on, everybody? Welcome back to Man Views. As always, I was at the very end to share my thoughts and comments. Let's go.
And for further proceedings regarding the verified motion to modify custody. Court will first make the observation. This is the first setting in regards to this motion. The court has reviewed the motion, finds that it's properly verified, and does colorably state a prima facie case, which warrants this court taking further action in regards to this motion. Ms. Martin, are you opposing the relief sought in this motion filed by Henry?
For overnight, yes.
Okay.
I'm totally okay with him getting parenting time a few hours throughout the week and a few
Okay, you
days.
say that. Okay, let me stop you there. You've read the allegations in this motion, and Henry says that he hasn't had parenting time since December, if I recall. Why is that?
Because one night I was asking, he had her all day, and I asked him to call me after her nap. He did not contact me all day, and he'd already had her the day prior to as well. And I was just wanting to get in contact with my child and seeing how she was doing. And then it came into a whole argument that he wouldn't let me contact her. He wouldn't let me see her because he was too afraid that she'd want to come home if she's seen her mom. And so then I said, well, if you're not going to pick up the phone, then I'm going to show up and I'm going to take her home with me. And then he made me have to call the police to be able to even see her. So, and to get her back into my custody. So since then, the cop told him that unless there was a court order in place, that he could keep her for as long as he wanted. And I'm not okay with that because I'm the one who's been raising her for 3 years all by myself. He's been in and out of her life.
Okay, and the little girl is 3 now?
Yes.
Okay. I trust, Mr. Blanchard, that your client is still pursuing the relief sought in his motion for this court to adopt a new parenting plan?
That is correct, Your Honor. I'd like to have the opportunity to argue if the court will allow it.
You may.
Okay. Your Honor, we dispute much of what Ms. Martin has already stated. My client said that whenever has a child in that particular weekend, which would have been the weekend covering December 20th, that she was blowing up his phone with text messages and phone calls, and finally it was interfering with his opportunity to have meaningful contact with his child, and he just stopped responding and stopped taking her calls because it was just relentless. And then she's the one who called the police and came over to do a welfare check. And my client, as I stated in my motion, he complied with the police officer's request. He brought the child out. The police officer noted there was no problems with the child. The child did go to see the mother, and then the mother wouldn't let him have the child back, even though there was an agreement that he would have the weekend and the overnight. And they had actually modified the existing parenting plan where he was starting to have more time with the child, including weekends. And then when he said, I want my child back, the police officer said, do you have a court order which gives you overnights? And he said, no, I do not. So he said, I don't have any authority. This is a civil matter. Bring this matter to court. So that's where we are now. Then from and after December 20th, he's had no contact whatsoever. Ms. Martin has said over and over again that she is the sole parent in this matter, that what she says goes. I have attached several exhibits, many exhibits in which she states that same thing, and saying she doesn't care what he says, she makes the determination. My client said that he has worked hard to have a relationship with his child, that his parents are here and they have a relationship with the child. And to be cut off from this child for 77 days now has been extraordinarily difficult. I don't want to go through point by point in my motion because the court has already read it, or point by point with regard to my exhibits. But I would point out that one of the things we stated in our motion is that Ms. Martin has a habit of smoking marijuana consistently. In my exhibit 8, she talks about her purchase of marijuana when she has a text message with my client. We certainly ask that she be required to submit to a hair follicle drug test today at our cost. Let us know where it would be done in El Dorado, and with our firm credit card, we'll pay the cost. If the court wants my client to submit to a hair follicle drug test, he will do the same thing at his cost. We've asked for some pretty serious changes in the custody arrangement. We've asked that he be designated as the primary residential custodian, And we think that's appropriate under the circumstances. I point out in my motion, the fact that she has violated virtually everything in the temporary parenting order about how you parent a child together. And then under the statute 233203, I point out 7 or 8 issues where it certainly favors my client. The rest are neutral or not applicable. He wants to be involved in his child's life. I put first, we want him to be the primary residential custodian and giving her regular parenting time. The second thing is, although it'd be difficult under the circumstances, he would work his best to do a shared residential custody arrangement, but that implies that both parties are able to work together. We think that she has not been willing to work with him. And with that in mind, that would, I think, support more him having primary residential custody and her having a regular parenting schedule, which we have proposed to be every Wednesday from after work till 7:30 or 8, and then on the weekends that she have every other Friday from 5 or 6 until Sunday at 5 or 6, and follow the holiday schedule that was in place in the original parenting plan. We think it's a strong basis, Your Honor, for the court to honor our request at this time, and that's what we're asking. And at the very minimum, that the court would order a regular parenting schedule, which is our our exhibit. I'm sorry, it's our exhibit 4.
Which is alternative mom primary. Is that the one you're referring to?
Well, the last one is, and it's just because we want regular parenting time that she would be primary, although we don't think she deserves it, but anything to get him started to have meaningful contact with his child. And that's the last gasp that we'd have, but we do think that we've justified a reason for changing custody in our motion and arguments today.
All right. Ms. Martin, I'm sure you're familiar with the proposed permanent parenting plan, alternative mom primary. And what's wrong with that plan?
Me being alternative or me being primary?
You being primary, but it sets forth, I think, a rather structured and actually a fairly common parenting time schedule for the father. Are you just saying that he shouldn't have the child overnights ever?
Not until she's old enough, like a little bit older. She screams and cries even when he comes to pick her up just for a few hours. She doesn't want to unlatch from me.
Okay.
I feel like she's not comfortable enough to stay overnight. She's been with me for 3.
Of course, keeping the child from the father for over 70 days, doesn't that help contribute to some of that? Deprivation of the relationship between father and child, you don't think that has a negative effect on the child's willingness to go see her dad?
No, because before I was allowing him to have a lot more than even what we had scheduled. I was allowing them to have a lot of time and she was still doing it.
Okay, now I'm going to go back to Mr. Blanchard for a moment. Mr. Blanchard, tell me about your client's household. What environment does this child go into when she goes to visit her dad?
Okay, my client has a significant other, a fiance who's a very good person. She's about to have their child together. There's a 2-bedroom house. The child of the parties has her own bedroom. The new baby will be in a bassinet in their room for a period of time. In her living arrangement, as I put out in my motion, she has 6 people living in the house, and the child sleeps in the room with her and sleeps in a bed with her. We would also dispute her allegations that the child screams and doesn't want to go with the father. That's not my client's experience, nor is it the experience of the grandparents who are here or his significant other who is also here. And if we went to an evidentiary hearing, all these people would testify as to a good relationship with the child when he's allowed to have contact with the child.
All right. Thank you for that additional information, Mr. Blanchard. What is apparent to the court is that the parents aren't working well together to share parenting time and parenting rights involving this child. The court generally is fairly protective of newborns, small infants. The court is always trying to be cognizant of who's qualified to really raise children of that age. But this child's toddler age. She's 3. And I'm sure she's a handful at times, as 3-year-olds are. Mr. Matlock, are you really in a position to handle as much parenting time that's that's on your schedule, which is a full weekend at a time and every Wednesday night?
Yes, we've actually done it for longer. It's usually a Wednesday and a Friday every week, and then we get some weekends. Whenever we have her, we have no problem with her. She's well behaved. We get her in bed at a reasonable time, 9 or 9:30, and she's up the next morning at 7 or 8. We have breakfast, lunch, and dinner. Kindle's got educational games on her phone that help her with her speech and pronunciation that she actually really liked. We have no problem with her, keeping her entertained and eating healthy meals and just keeping her.
All right, Mr. Matlock, what about this claim that the child has real adjustment problems for several hours after going from the mother's home to yours?
In the beginning, yeah, it was a bit of a struggle to get her used to sleeping over at my house, but by the third night that we had her, not third night in a row, but just third night in general, she was having no problem going to sleep. She doesn't have any problems going to sleep. I could tell her to go to bed and she'd fall asleep right there. We do. I'll read her a couple of books that we have. She likes to read Dr. Seuss, Green Eggs and Ham, and we got a couple of Bluey books that she likes me to read to her. After that, she's out cold the whole night. No problem.
Okay. I expect straight answers on this, Mr. Matlock. Are you currently on probation for any offense?
No,
Do you have any criminal cases pending?
I do not.
Ms. Martin, I'll ask you the same questions. Are you currently on probation for any offense?
No,
Do you have any criminal cases pending?
no, Your Honor.
Okay. Again, it's apparent to the court that the court is going to need to set up a structured parenting plan for these parties to follow. And I'll warn both parties that if the court makes this order for specific times, I will expect both of you to follow it to the letter. If you can't agree on variations, which is a shame, and I think that's tragic, because special circumstances will come up from time to time. But I would really hope that you two can learn to work together to be a little bit more flexible. But the court, I think at this point, needs to set a rigid schedule. At least at this point, the court will implement the proposed permanent parenting plan, though I'll call it a temporary parenting plan. Alternative mom primary, which was filed in the case. I don't see an exhibit number on it as far as the court file is concerned, but it's the proposal which calls for the father to have parenting time every other weekend from Friday at 6 p.m. to Sunday at 6 p.m., every Wednesday from 5 o'clock p.m. to 7:30 p.m., and any other time that the parties mutually agree upon in writing, which I don't have any real optimism is going to happen until you two develop some sort of cooperation and rapport with one another. But I do want to set forth that every other weekend and every Wednesday night schedule. I think this child needs to get reacclimated to the father and the father's home. And I find it tragic that there's been a long deprivation period here because the court believes that the Wednesday night should be the first visit rather than an overnight. Next Wednesday will be the start of this parenting plan. I trust starting your weekend, not this weekend, Mr. Matlock, but the weekend after is consistent with your schedule?
Yes.
So yes.
Okay. So the mother will have this upcoming weekend, and then you would have the one after that on the every other weekend rotation. That gives you the Wednesday night to kind of get reacclimated with your daughter. There may be a little bit of transition problem there at first. She hasn't seen you for a while. I'm sure that after a couple hours, she'll get reacclimated and she'll be in a better position. I don't see any solid grounds here to avoid overnight visitation between father and child. I don't see that in any way he's forfeited his rights to do that. I think that maybe you two shouldn't be contacting each other during periods of the other person's parenting time. There apparently has been a problem with multiple phone calls and texts and communications. Mr. Matlock, you're the child's dad. You don't have to give constant reports to mom. You don't. But I would say this. There is probably no greater resource for information concerning your daughter than mother. Use her as a resource if you need her. if she starts acting a certain way or start developing a certain problem, giving her a call or sending her a text, hey, here's what's going on. You have any ideas about how to deal with this? I know it's hard for you to do, but again, she knows the child, as well as anybody, if not better. So use her as a resource. I also am somewhat optimistic here, Mr. Matlock, that you have a significant other in the house who's about ready to become a mother herself.
Yes.
Fair statement. And then you have some supportive family around you.
Yes.
Is your mother, does she live close to you?
Yeah, we have my mom and then Kendall's entire family. We've already talked to them. They're more than willing to help us with lyric whenever we need
Okay.
to.
Other than the mother of your child, your mom is probably the next best resource if you ever need any parenting direction. Okay.
Yeah. Yeah.
Don't hesitate to use her as a resource if you need to. All right. I think that this is an appropriate temporary parenting plan. Mr. Blanchard, I know you have not had an opportunity to confer with your client about this. I will need to know at some point whether your client is going to be satisfied with that as the ultimate result of his motion currently before the court or not. I know that may need some discussion.
Your Honor, we would suggest a review date. We understood that there would probably be a transition period that would be ordered by the court. That's why we proposed the alternative plan. We would like perhaps a review date, and we'd also like the court to rule on whether or not both parties should submit to a hair follicle drug test. If Ms. Martin, as we suspect, would show up with at least marijuana in her system, we'd like the court to have that information, and we'll pay for the cost, and my client will submit to the same hair follicle drug test.
That request is currently denied as to both parties.
Okay. Can we have a review date, though? Perhaps maybe.
That I will set on the calendar, Mr.
Okay,
Blanchard.
thank you. I would suggest a couple of months down the road, Your Honor.
I would agree, Mr. Blanchard. I think that's an appropriate proposal. I want to see how this goes. Mr. Matlock, you need to exercise each one of these visits that the court has ordered.
Yeah.
I mean, if you want these parenting rights, you have to exercise them.
Right.
And I expect you to be there during these parenting time periods. Now, it's not your significant other's parenting time period or your parents, it's yours. I expect you to be actively involved. If you got a 3-year-old girl in the house, you don't have any choice but to be actively involved. It's a busy time, Mr. Blanchard. Let me see if I can find an appropriate date. Mr. Blanchard, if I were to propose 11 o'clock a.m. on Monday, May 12th.
Checking, Your Honor. I'm an old guy. I just do a paper calendar. So.
Oh, no, that's the best kind, Mr. Blanchard.
Yeah, 11 o'clock on May 12th is open, Your Honor.
All right. The court will conduct a Zoom status conference May 12 at 11 o'clock a.m.
Okay.
Further proceedings in the case, I will make both parties aware the court would consider modifying orders at that time to the parenting plan if the court believes it's necessary. And with that date now set, May 12, 11 o'clock a.m. by Zoom, I do wish to make this point. Ms. Martin, you do not have a superior right under the law to custody of this child. A father has just as much right to make a legitimate claim for custody as you do. You have been the primary parent. I have no doubt you love your daughter. I have no doubt you care about her. But if you can't work with the other side, what the court has an option of doing and has exercised before is place the child primarily with dad and see if he will work with you better than you work with him. So my admonishment is follow this parenting plan, find a way to work with the dad. You've got 15 more years plus to work together concerning this child's welfare. You need to start now to really develop cooperation and a rapport so that she doesn't see conflict between the two of you. And she has a normal relationship with her mom and a normal relationship with her dad. I expect you to be equally willing to work with mother, Mr. Matlock.
Yes.
All right.
Your Honor,
Mr. Blanchard, memorialize this temporary parenting plan in a court order stemming from today, setting forth the date for review in such order. Is there
I will,
anything
Your
else,
Honor.
Mr. Blanchard, we need to address today?
No, Your Honor, I'll prepare an order and the parenting plan I've already prepared and submitted to the court. Do I need to submit it to Ms. Martin for her approval first?
You do.
Okay, we'll
Ms.
do.
Martin, he's going to submit the proposed order. You may not agree with everything that the court's done, but if it accurately reflects what the court has done, you need to give him your approval promptly. I don't want that order held up. I want to make sure both parties have an order they can show law enforcement to make sure the other side is following it. So the sooner we get that signed and filed with the clerk's office, the better off everyone is.
Okay.
And I have no doubt Mr. Blanchard will be very, very prompt in the preparation of this order.
I'll try to have it out today, Your Honor. Thank you.
Excellent, Mr. Blanchard. I appreciate that commitment. Good luck to both parents in working together for the best interest of their child.
Okay, let's get to it. From what I saw, I don't like how the judge barely got on the mother. It seemed like he was getting more on the father, scolding the father more than the actual person that was causing the issue, right? This woman made that child lose 70 days bonding with her father. Like, come on. Now, for his lawyer, what he should have done is, in his motion to modify the time sharing plan, the temporary time sharing plan, he should have also included to hold her in contempt and also include makeup time sharing. Now, a judge that's like on his or her P's and Q's will be like, you know what, ma'am, you denied that father 70 days and you went against our court order. So therefore, I will hold you in contempt. Because just because it's a temporary time sharing plan doesn't mean it's not a valid court order. You still got to follow that, right? So it's just weird how the mother, out of spite, made that child miss 70 days bonding with the father because simply he stopped answering her phone calls. Ma'am, you are very childish, bitter, spiteful. And as we dig more and more and more, we discovered that, okay, the father moved on, have a girlfriend, and expecting a newborn. She ain't like that. It's out of jealousy, out of bitterness, and she's talking about, oh, he's been in and out the child's life for the past 3 years. No, it seems like, and it sounded like you intentionally kept the man away from the child the past 3 years. Notice how she said, in the past, I've allowed him to see my child. Whenever you hear a mother say they've allowed a father to see their child, right? To see my child, that shows a sign of bitterness. What do you mean you allowing that father? That's his child as well. I like how the judge said, listen, you don't have the rights to the child only. It's not only your child. Imagine if the father was the one that kept the child for 70 days from the mother. Oh, he'd be in jail. Definitely. He'd be locked up. Now, here's one little tip and trick that moms like this would do. What they would do when they have the child, they will, as much as possible, try and force the child to love them more. Right? They're trying to do extra stuff like make the child be very attached to them. Right? So that way when the child go see the father, so the child can want them instead, because the child's very, very young, right? And then what they'll do too, her calling constantly, is when the father is with the child, these type of BBMs will call the father during time sharing days specifically just to have the child see her face so the child can want to go back to mommy. These are things, the little psychological game that they play with the child's emotions and psyche. And if you're not aware of that, fellas, it will go over your head. Be very careful. They play this little mind game. They use these kids as pawns, weapons, to harm you, to hurt you, right? So it's disgusting that you kept that child. But the sad thing is, man, look, honestly, was I shocked with the ruling of the judge not really holding accountable? Honestly, no. These type of BBMs rarely get held accountable. They rarely get held in contempt. And this is why they'll do the same thing over and over again. This is why they feel like they have power to just decide when to deny you time sharing. This won't be the last time they'll be back in court. They'll be back in court over and over again until she's held accountable. So I'm not shocked, really. I'm not surprised. Like, I'm very numb to it by now. But overall, man, look, I wish that father the best. I wish the mother the best as well. It's sad and sickening because the child, when they're suffering, you are taking years and days of that child bonding with her dad. And you know how daughters love their dads, right? You are robbing that child out of a wonderful gift. So my messages to y'all is, to any moms watching this, please stop being bitter. Please move on with your life. If a dad want to be involved, let the father be involved. As a matter of fact, let's just say, okay, cool, the father wasn't involved, or he was in and out 3 years of a life. Okay, cool, now you want to come back in. So what? So what? So what? He want to come back and be a full-time dad. Why are you taking this personal? When the child is born, write this down. When a child is born, you are no longer the main character. You are not a supportive character. The child is now the main character. So what the father was in and out for the past 3 years, right? We're just saying based on what she's saying. But the lawyer said, okay, that's false, right? So we know that they said, nah, she's lying. But let's just say, because a lot of moms will use that as an excuse. So what? He said, you know what? Fine, listen, cool, I'm back. I want to be in the child's life full time forever. You can't be like, well, no, because you wasn't around the past 3 years. So no, see, you making it personal about you. Let the father be involved. You saying because he was in and out, that's why he shouldn't be a father to the child. That's a personal problem you're making it. That's you and your feelings. That's you trying to get, I guess, what, revenge or be spiteful. Like, who cares? Because if you go to the courtroom, they're gonna say, listen, whether or not he was around the past 3 years or not, do you know what the judge is gonna say? As you've seen today, listen, the child need a father. Now, of course, it might not be off the bat 50-50 custody or full-time sharing and full overnights. Yeah, they're going to work their way up. But regardless, at the end of the day, their main goal is to eventually have that father in that child's life. So you hold no power to say, well, since he was in and out, for that reason, he won't have any kind of custody. I'm just saying overall, I'm just trying to give y'all, anybody watching this, a certain less, because I see a lot of moms be saying that. Well, he wasn't there when I gave birth, so that's why. Who cares? I know it sounds harsh, me saying who cares. He didn't come to your actual birth when the child was coming out. This is more of an emotional problem. It's a personal problem that you have, a personal vendetta. Don't put that on the child. The child and you are two separate entities. Anyway, I know y'all gonna eat me up for this for that comment. Y'all gonna disagree, but it is what it is, man. But look, on some real notes. Parents, love the child more than you hate each other. So, but look, what is your thoughts? All right, comment below. What do you think about this entire video? And of course, you might agree or disagree with my comment. It is what it is, but let me know below how you feel. And as always, don't forget to share, like, comment, and subscribe. Peace.